In the matter of SHAHED KAMAL versus MS-A SURTI Developers Limited, Supreme Court allowed the appeal and set aside the judgment and order passed by High Court at Bombay. Court said that a right to protest peacefully without falling foul of law is a corresponding right which the consumers ought to possess just as the seller enjoys his right to commercial speech. Any attempt to portray them as criminal offences when the necessary ingredients are not made out would be a clear abuse of process and should be nipped in the bud. Not satisfied with the services provided by the respondent developer in this case, and when, according to them, repeated entreaties did not elicit a response, the appellant home buyers decided to resort to a unique form of protest. They erected a board or a banner visible to the public at large, setting out in English and Hindi languages the following statements. We protest against the builder Asurti Developers Private Limited for not forming society even after 18 months broken podium, not giving society accounts, not cooperating with residents' shabby garden, not attending to builders' defects, not sorting water issue, ignoring grievances, poor lift maintenance, leakage problem, non-cooperation, plumbing issues, dirty bouncy approach road. We protest for our rights. Respondent developer hit back and threatened to sue them for defamation unless an apology was tendered. When appellants refused, criminal complaint was filed for offences punishable under Section 500, read with Section 34 of Indian Penal Code 1860. Metropolitan Magistrate Court, Borivali, Mumbai, after perusal of the complaint and verification statement of complainant, issued summons against appellants for offences punishable under Section 500, read with Section 34 of IPC. A challenge and revision having failed, appellants approached High Court by way of writ petition under Article 226 and 227 of Constitution of India, read with Section 482 of Criminal Procedure Code 1973, seeking to quash the complaint as well as summons issued. High Court having turned down their plea, appellants came before the Supreme Court. The short question before Supreme Court was whether complaint filed by respondent makes out a case for offences punishable under Section 500, read with Section 34 of IPC, against appellants. Court said that it has been held by Supreme Court in Chamanlal versus State of Punjab that under the ninth exception to Section 499, if the imputation is made in good faith for the protection of the person making it or for another person or for public good, it is not defamation. It has also been held that interest of the person has to be real and legitimate when communication is made in protection of interest of the person making it. In case of Javed Ahmed Hajam versus State of Maharashtra and another, Supreme Court observed that right to dissent in a legitimate and lawful manner is an integral part of rights guaranteed under Article 19(1)(a), and every individual must respect right of others to dissent. Though said in context of actions by government in said judgment, the court observed that an opportunity to peacefully protest is an essential part of democracy. Supreme Court in Anita Thakur and others versus Government of Jammu and Kashmir and others held that holding peaceful demonstration in order to air their grievances and to see that their voices are heard in relevant quarters is the right of the people. Supreme Court held that such a right can be traced to fundamental rights guaranteed under Article 19(1)(a) and 19(1)(b) to assemble peacefully and without arms, and 19(1)(c) to form associations or unions or cooperative societies. The court recognized the right to raise slogans, albeit in a peaceful and orderly manner without using offensive language. Manner of the protest resorted to by the appellants was peaceful and orderly and without in any manner using offensive or abusing language. It could not be said, said the Supreme Court, that the appellants crossed the Lakshman Rekha and transgressed into the offending zone. Their case wholly falls within the sweep, scope, and ambit of Exception 9 to Section 499. Their peaceful protest is protected by Article 19(1)(a), b, and c of the Constitution of India. The criminal proceedings levelled against them, if allowed to continue, will be a clear abuse of process. Peaceful pamphleteering has been held to be a form of communication protected by the First Amendment in the United States of America as well. It has been held that by such peaceful activities the effort was to influence the conduct of respondent, and such activities not ought not to be injected. Organization for a Better Austin versus Jerome M. Keefe case. In an interesting judgment of US District Court for Eastern District of Wisconsin in Concerned Consumers League versus O'Neill, it was held that just as sellers have access to consumers via advertising, peaceful informational activities by consumer organizations must also be protected. Also, Supreme Court referred to a case Tata Press Limited versus Mahanagar Telephone Nigam Limited, where it was held that a commercial speech was part of freedom of speech guaranteed under Article 19(1)(a, so was subject to reasonable restrictions under Article 19(2). The court held that in a democratic economy, free flow of commercial information is indispensable.